Okay, great. Thanks, Judge. So I'm going to pick up where Matt left off. He was doing a couple things. He was taking offenses, burglary, looking at the elements of the offense and the grading of the offense, and then using that to identify the offenses for which he's getting data, right? So those medians we had are linked to elements and grading of offenses. And one of the things about that approach that's helpful is it sort of combines the idea of using data and of some kind of policy framework. The example we've used before is you as a commission might want to group together offenses with similar offense gravity scores when there's serious bodily injury. Or you might want to have a consistent reduction in the OGS for an inchoate versus a completed offense. So there's some basic sort of rules of the road that you could put in place that would help to have consistency across the guidelines. So the idea is you first use the, I think we have a little accident, sorry. So you first, use the data and look at the elements of the crime and use that to come up with your assignments. But what the commission has traditionally done over the years is also use sentencing factors, not things proven at trial, but determinations made by the court at sentencing. And even after, Aileen and all those other cases that dealt with guidelines and mandatories and statutory maxes, the courts have held that with advisory guidelines like we have in Pennsylvania, courts can make decisions or determinations at sentencing based on a preponderance of the evidence, and those can be used for guideline recommendations. And so that's been a consistent part of how we do guidelines in Pennsylvania. And the first example I'm going to pick up on is where Matt left off. And it's looking at those same kind of distribution of sentences based on a conviction offense, in this case, A30, possession with intent to deliver. And we're just going to focus on heroin, because what the commission does under the guidelines is we subcategorize based on sentencing factors. We say it's a conviction for A30. We got that. What was the drug? What's the quantity? And we're going to come up with different OGS assignments based on that. And so it sort of leads into this idea of adjustments to the guidelines. We start by doing OGS assignments based on elements and based on data, but we can refine that further if we build into the guidelines sentencing factors that courts consider based on a preponderance of the evidence. And we've done that for years, and we can continue to do that. And the more we do that for common kind of factors that are found, the more consistency we have in the guidelines. So that's sort of the argument. So we're going to just buzz through these heroin slides. So the first one is heroin, the amount's less than 1 gram. Remember, we're always talking about when this offense is the most serious offense of a criminal incident, and we're talking about a 0 prior record score, and we've removed from this enhancements like the deadly weapon enhancement or the school zone enhancement, and we've removed inchoate. So these are completed offenses. This is a drug delivery. It's not an attempt to that. So, so you can see in this first slide that for less than 1 gram of heroin, the median is 3 months. The standard range under the current guidelines is 3 to 12 months. So the median is at the sort of the lower base of that standard range. 63% of the cases are within the standard range, and there's 32% in the mitigated range, which would be probation. Now, I'm not going to go through all the details that Matt did and try to assign this to the new guidelines, but I just want to show you the difference in looking at these distributions when you consider a sentencing factor like weight, because heroin's going to be the offense, is going to be the drug, and the offense is going to be an A30 conviction. So this is less than 1 gram, and the median is 3 months. This is 1 to less than 10 grams, and the median goes up to 6 months. 10 to less than 50 grams, the median stays at 6 months and is now a mitigated sentence. 50 to less than 100 grams, the median's 11 months, still in the mitigated range. And then we see 100 to 1,000 grams and greater than 1,000 grams. And you can see that, there's not a lot of cases that we're talking about, but we're talking about a median of 11 and a half months in terms of the 1 to 1,000 grams. I point this out because one of the things the commission might want to consider is how we deal with weight categories or drug-related categories or A30 or other drug offenses. One of the reasons we have all these categories is that we were tracking the drug mandatories and providing a sentencing guideline alternative to the drug mandatories. Those drug mandatories have been invalidated. And the ones that remain are the, not as drug mandatories, but the large categories of drug PWID are used as eligibility criteria for some of the programs like state drug treatment program. One of the things to think about is whether there's another way to consider drugs for purposes of guidelines and sentencing factors. Back in the 90s, when we incorporated drug treatment into the guidelines through county intermediate punishment, a lot of the discussion was about sort of 3 categories of drug offenders. You had users that were dealing to support their habit, and you had dealers. And there was sort of agreement about those being the 3 categories. What there was never agreement was what are the thresholds and how do you define those 3 categories? And I'm not sure that we have, a clear definition now. But I think there's a lot of benefit in thinking about whether there's a different approach to how we deal with PWID or other drug offenses in terms of what are meaningful categories. Because it simplifies the guidelines if you have a meaningful description of that offense, of use versus use to support, dealing to support your habit versus a dealer. And if we can come up with something closer to those 3 categories, then I think, we can think about that in terms of what are the sentence recommendations that seem appropriate. When is treatment appropriate? When is state incarceration appropriate? How does this all fit together? Instead of having, 4 or 5 or 6 categories that sort of lose value as you go. It's just this sort of incremental buildup. So we don't have an answer. We're just saying that there may be some benefit in terms of simplicity and in terms of utility if you thought about ways of categorizing drugs separately from the old mandatory thresholds that are no longer in place. So it's sort of an opportunity for the commission to sort of reframe this. But I think there's important distinctions. I think, major dealers have to be treated differently than the others we're talking about. But we don't need all of these distinctions, that there's very few numbers and there's not, much in terms of the guidelines except complication. Chairman.
So, I don't know, as a legislator who we spend a lot of time in the legislature talking about heroin, and my head wants to explode when I see all these mitigated range sentences for the higher weights, which would seem to indicate to me that those are for-profit drug dealers at the higher weight levels. In terms of the commission, though, I guess, how much of our sentencing policy should be driven by the sentences that, like, I don't know if we should be conforming our guidelines to the sentences that we're seeing versus trying to effectuate change to reflect legislative policy over the years. I mean, it's not a secret that the legislature has been really trying to focus on the heroin epidemic and a number of different levels, from treatment and treatment centers and reforms there and everything else like that, clear through the criminal justice system. And it just seems like the sentences, based on this data anyway, are not reflective of that. And I'm trying to get my head around the role of the commission and whether we're just supposed to comply with, the 2019 sentencing data that we've seen and say, well, conform our sentencing matrix to what has been handed out, or whether we need to say, well, the legislature clearly has placed an emphasis on heroin and recognized or identified it as a serious health problem across the Commonwealth. And so if these sentences aren't complying with that broader policy concept, should we be doing something to try to drive the sentences in that direction?
Sure.
Any comments on that?
Yeah, absolutely. I think what I said is, I think consistent with the legislative directive, because I think the legislature talks about users versus users dealing to support their habit versus dealers. And so I think those three categories, are finding a way of describing or defining or applying those categories to the guidelines, makes a lot of sense. And I think what we've talked about all morning is starting with descriptive data. And I think that might be most helpful when you're looking at those lower two categories. And I think if the point is that you need to be prescriptive for the higher categories because the high departure rates, things like that, and it's inconsistent with the policy of the General Assembly, I think you can do that. And I think that's an example of what we've been talking about all morning, about starting with the data and then determining if you need to override the data based on a policy decision. And I think I don't think it's a one size fits all for drug offenses. I think you could use data for the lower categories to try to guide what the appropriate OGS assignment is. And you can do something different with bigger categories. And I think the issue is, where do you draw the line? Where, at what point are you in the top category? And then how do you define that middle category? And we had, I remember back in the 90s, we were talking about cocaine and, 8 balls, and is it 3.8 grams? Or, where are we going to draw the line? Is it 2 grams? Is it 5 grams? 2.5? Is it 10? Is it 15? And we spent a lot of time on those kind of discussions. And I think what you raised is a really good point about trying to define some clean categories and then making a determination if it's descriptive or if it's prescriptive. How you're going to approach it.
If I can hop in on that a little bit, one of the thoughts I have when we're looking at the broad use, although we're talking about descriptive in terms of the median, a lot of prescriptive decision-making went into that. So when the judges are looking at the guidelines, when you have a 3 to 12 month range, and we're looking at these numbers, that's because judges are looking at individuals and they're saying, within this range, I have a lot of things I need to look at. Is this person doing it for this reason or that reason? So there is sort of some prescriptiveness built into those numbers because of the range that the judges have had at the time of sentencing anyways.
I think that's true. And I think one of the gaps in our recommendations and in our guidelines is that we have nothing about problem-solving courts. We have nothing about those types of recommendations. We did I think a great job in the 90s with the trade-off with comprehensive drug and alcohol treatment, getting funding from the General Assembly for that. I think that was exactly what we should have done, and I think it was well done. And it'd be great to continue that effort. But we don't say anything about problem-solving courts. And you may be right, Judge, that some of these mitigated sentences or departures may be treatment programs that are just showing up as probation or something like that. So, one of the things we've talked about in the various study committees have talked about is trying to figure out a way to build problem-solving courts, comprehensive treatment, other things like that into the guidelines, and not limiting it to people that qualify for what was county intermediate punishment, trying to sort of figure out sort of in tougher cases, how do you build in drug treatment in an appropriate way while protecting the community? And that's a tough call, but we could do more there because we don't talk about problem solving courts.
Mark, to that point, having been, I preside over drug court now, there's such different approaches county to county. Our county lets in burglaries, felony drugs, violent crimes. Other counties I know do not do that. Some counties right around here. But I don't know how you incorporate that where, then it ends up being a huge departure from the guidelines for the DA to put somebody in, like that. And then to the other point, I get what you're saying about the weights, but trying to narrow those categories. But I think that's difficult when your new grid narrows the range of sentences now too.
Right.
There's not I understand what you're saying, but now you're going to try and combine maybe a few of those categories and plug them in an area where even if we're in the state prison realm, you've got 6 months leeway, but if you're in the county, you only got, the usually 2 months, maybe 3 months if we're at that 9 or less than 12. So, I think there's a conflict there. And one thing I'll say with heroin is, and this goes back to the days that you're talking about when we talked about the mandatories for heroin and things like that. And this was even pre the big opiate crisis, like a gram of heroin's a hell of a lot of heroin.
Yeah.
That's different than cocaine, obviously different than marijuana. That's a significant amount of heroin. If you're talking 10 grams of heroin, at least in this county, and I think most third-class counties, I can't speak for Philly or Allegheny, over 10 grams of heroin, you're a significant dealer.
Sure.
And then I'm sure when you're getting up over 100 grams, and I'll defer to EA, those cases are probably going federal. There's not probably a whole lot of those staying.
Yeah, Judge, I agree with you there. And look, fentanyl's even, beyond heroin, certainly, and all of that. I guess my point is maybe it's not weights that we're talking about. Maybe it's the nature. I mean, maybe these are sentencing factors. They're not elements being proven at trial. And it's convenient because you have numbers and you have weights, you have metrics basically to use weight categories. But is there another way of thinking about how we deal with drug offenders? And I'm not saying, that we don't do exactly what you're talking about with people that are trafficking, but it seems sort of artificial to say, oh, it's 10 grams the threshold. And if you're on this side of it, you're A-okay, and, you're the other side of it will slam you. I think, thinking about if it's a sentencing factor, is there a different way of characterizing these differences? And is it role? Is it, is there something different than just weight thresholds? But maybe that's the best we can do, but that's been sort of this continual discussion around drug offenses. So I wanted to raise it as we're talking about these sort of adjustments to the guidelines, because we're talking about factors that there's the burden is lower, and it's a determination by the court, and that's a lot different than an element being proven at trial. And I think we have some flexibility. And let me, I know we're moving towards the lunch hour. Let me just mention one of the handouts you have. There's a one-page sheet, way too small a font, but it is. But at the top, it says offense gravity score assignments with misprints. I think it was supposed to be promoting uniformity and proportionality. But what we did was we tried to look through the current guidelines and tried to look at both elements of offenses and other sentencing factors, including enhancements. And there's just this like really rich collection of factors that are considered as part of the guidelines. And if you look at the top, these are primarily elements of the offense. So if you look at A3, specific elements included, there's a lot of different details that we build into the guidelines to differentiate cases. And, you know, some of that involves things like degree of culpability, you know, threatened versus attempt versus cause. When we were talking about murder 3 in one of our advisory panel meetings, we talked about the difference between intentional and knowing and negligent and reckless behavior. Type of harm, is it a person or property or society? And if it's a person, how do we recognize age or vulnerability or some of the enumerated persons like in the aggravated assault statute? If it's degree of harm, what about bodily injury versus serious bodily injury versus death? When we get to weapons or instrumentality, we talk about the type of a weapon. Is it a gun? Is it a knife, et cetera? But we also talk about whether it was loaded or unloaded. So we have a lot of kind of factors built in. Was the person authorized or licensed to have a weapon? And then the role of the actor in the offense, the main actor or an accomplice. As elements of the crime, we also have 3 enhancements that are based solely on elements. So the enhancements we have for home invasion burglary, for robbery of a motor vehicle, and for person not to possess a firearm, those 3 enhancements are based on elements of the crime. You prove the elements at trial, and the enhancement is then applied. So I just wanted to provide you with this list because there are also times when those same factors are in play, but they're not elements of the offense. They're considered by us as sentencing factors. You know, it could be that the elements of the offense do not talk about a weapon, but we see weapon as an important factor, and we include it as an enhancement or as a sentencing factor. So I think as you look down in the lower section, you'll see that, you know, the commission has a lot of latitude in coming up with the rules of the road that take into account these other factors. And the way we get at that is we build them into the guidelines. So we either, traditionally, what we did was we subcategorized offenses. We take this offense and we create a lot of different OGSs based on sentencing factors. Or we have an enhancement. General Assembly has been generous in giving us a lot of enhancements to build into the guidelines. And many of those are not elements, they are sentencing factors. So the court's making a determination prior to sentencing, and then the guidelines say, now you have to adjust the guidelines to build this in. And then that's your starting point for sentencing. What we're talking about this morning, what we have been talking about this morning, is coming up with a way of organizing the work of the commission around offense gravity, of looking at statute and the elements, looking at other factors you think are important that should be considered as part of the guidelines, whether they're enhancements or not, and then coming up with sort of a framework that we are using to organize offense gravity. And one factor of then assigning the OGS is to look at the data. Just look at the sentences that the median sentences we're getting. And does that median sentence fit into the framework that we're talking about, or is it an outlier? And if it's an outlier, maybe that's where we have to dig a little deeper, see if it was, you know, something bad about that year or underreporting, or that there's just a disconnect between what judges are doing and prosecutors and defense attorneys are negotiating and what we're recommending as a commission. And then that's where the commission has to decide which do you favor. And I think in a lot of cases, just like the discussion we had, the commission looks to the General Assembly. We're an agency of the General Assembly and tries to promote that policy in place. And that would be an override of what might be median sentences. So as Matt said earlier, and I think, you know, I'm going to sort of close with this, we're just trying to figure out how we can help you to do your work. Because when we have thousands of offenses, there is some benefit to using these computers that we have to sort of give you a head up, a step up to run the data to try to figure out what would be the initial assignment based on the median sentence, or what are the initial ranking of factors that you think we should have in place. And one of the things I mentioned in some of my slides, I don't think I mentioned it earlier this morning, but in North Carolina, back in the 90s or maybe more recent than that, they were doing a recodification of their system. They were rebuilding their guidelines, they were rebuilding their statutes, and they came up with some simple principles when they were thinking about how do you rank order seriousness of offenses. And when they thought about harm, they thought about person first, and then property, and then society. And so if you look at their guidelines, if you look at their statutes, you sort of get a clear sense of the framework that they had for coming up with what they viewed as like the most serious stuff that deserved the highest penalties and the least serious stuff. And then they used data and other things to start plugging things in. And you could see there were times when they swapped order or they overrode something that was in the data because they had a policy framework that said, no, we should treat all serious bodily injury in this manner. It should be at least X or something like that. And I think that's what we're sort of looking for as well. We think we can provide a lot of information to the commission in moving the offense gravity score assignment forward as we dig into this. So we wanted to, this morning, to share this information about sort of the data approach and offer to use the median to run all the data and come up with like initial assignments, see if it makes sense. We could also take these factors that I have listed on this sheet and try to come up with some kind of framework that's sort of guiding principles for levels of harm and things like that that could be used to sort of group offenses or order offenses. So I think these are things that we think would be helpful to you in trying to systematically approach this. And so at the end of the day today, we'll be coming back to this and just asking for your ideas, because I think what we could do as staff is in the next couple of months, we could compile some of this information, get it back to you, and we could start that process of thinking about assignments. Yeah, DA.
Quick question for you,
Sure.
Especially when we're discussing heroin and addiction. Do we know, so prior to, I guess, a few years ago, with regard to state IP, that was obviously something we had to roll in at the time of sentencing. That no longer occurs. The Department of Corrections makes that determination. Do we have any numbers on the number of individuals that are in that program since that change occurred? Has it gone up, down, stayed the same?
Yeah, we've had a discussion actually in the last couple of weeks with DOC on a number of things, and specifically about not just that program, but the other ones that came out of the JRI2, so short sentence parole and the changes to triple RI and so forth. We continue to work with them, but they've given us some information about their sort of decision process at classification, and we're meeting with them, I think, in another couple of weeks or something like that to continue that effort. So what we know is that because of the pandemic, there was just a real disruption of the whole process there, as you can expect. One of the programs that actually was, I guess, promising or was used a lot because it was a default program was the short sentence parole. And so because of the use of short sentence parole for these legislatively designated cases, that program was put in place. There were substantial cost savings to the Department of Corrections linked to that. And as a result, there's going to be JRI2 funding for the first year, where initially they thought there wouldn't be any funding. So the good news is that county probation and parole departments, if this is certified, and I expect it will be receiving some of that funding, the first monies in the JRI2 fund that was established. So, you know, it's good news for county probation and parole. It's good news for us. We get funding to help support SGS Web and things like that.
So at this
So-
point, we're not sure.
So, well, we know that it has been used. We know that to the degree, if you think about sort of a competition of programs, the boot camp is the one that is used least or has been used least in the last year. I think, as I recall, sort of maintaining sort of status quo, I think, was the drug treatment program. But there was, you know, everything sort of dropped because of COVID. But we'll continue to look at it and we can get back to you.
I appreciate that because I mean, that's a really very important factor.
It is.
I mean, I know previously we negotiated cases, we made offers based on essentially kind of forcing people into state IP.
Yeah.
And if that no longer is occurring, absent our making it happen, then that's something that is definitely a consideration.
Yeah. And keep in mind, the commission is responsible for doing an evaluation of programs like that. So part of our responsibility is one of the reasons we had the call was because of our responsibilities to do an evaluation of those kind of programs. And also because we're involved in correctional population projections. And that's a big part of it.
Thanks, I appreciate that.
Yeah.